actually violates some of the principles. Anyway, I won't go into that now because he's going to talk about it later in another chapter. But so the internal-external morality distinction and the aspiration duty chapter are different distinctions. And the one that's really important to Fuller is obviously the internal-external morality distinction. Are there any other questions of comprehension of what we saw last Thursday? So basically, just to refresh our memories before we start discussing. So again, it's a long chapter, and what I tried to sort of organize the presentation of the material around is the idea that there's something paradoxical about it. There's something paradoxical or even maybe contradictory about the chapter, in that he tells us on the one hand that legality depends upon the satisfaction of these 8 principles. Right? Legality depends on the satisfaction of these 8 principles, and in turn, legality, right, is the reason that ordinary citizens have to feel fidelity towards the law. Right? The fact that the law is not perceived by citizens by and large as just being a set of commands that make no sense, that seem to come from some arbitrary authority that just bosses us around, and is due to the fact that laws or at least legal systems that are worthy of that name, are governed by the principles of the principles of internal morality. So, on the one hand, they seem to be terribly important, and if you listen to the argument as I've just framed it, it would seem that any legal system has to aspire to realize those values to a maximum degree. Realize them to a maximum degree. But then he spends basically, 60 pages telling us that they can't, right? And they can't for a variety of reasons. They can't sometimes because circumstances arise that require, right, the use, for example, of retroactive law. This thing that is supposed to be an abomination, the idea that people can't govern themselves according to the law because something that they did yesterday is now being said to be illegal today, but applying to them for something that they did before it was illegal. This aberration is something that courts have to have recourse to on a number of different occasions. Sometimes in very sort of special circumstances. Remember the whole thing about the wedding stamp being the machine that makes the stamp being broken, and the weddings that would risk being. But more seriously, he says, look, when judges adjudicate conflicts, when judges adjudicate conflicting interpretations of a statute, they are actually, from the point of view of the litigants, making retroactive law, right? I thought the law said that I could bring my tricycle into the park. I thought that the law said that it couldn't bring my tricycle into the park. Both interpretations are plausible of the principle that says, we know which principle I'm talking about. Well, when the judge decides, there's one of the two parties for whom it will seem that retroactive law has been made, right? Applying law to particular cases in a conflicting interpretation, in a situation of conflicting interpretation of a statute means that somebody is going to perceive, not illegitimately, what has happened as the imposition of retroactive law. And this is supposed to be an aberration, and yet in any case of conflict, it seems inevitable that that will happen according to Fuller. Right? We also went very quickly on the question of laws requiring the impossible. Right? Laws requiring the impossible. So there are easy cases that we can think of that are kind of just toy cases that don't actually apply in law. If the law requires that you jump 100 feet in the air against physical possibility of human beings, then it's requiring something that's physically impossible. But Fuller spends a lot of time talking about the ways in which the law can't, but has no choice, but to sometimes hold people accountable for things that they didn't intend, despite the mens rea criteria, right? So every court will have to fix some kind of a criterion for when the ascription of intention is possible, and there will be some cases in which that rule that the court will have fixed about when intention can be ascribed will, in the case of a particular individual, make her or him liable for something that they didn't actually intend, right? Because of some deficit, some cognitive deficit or something or other. So there are times where the law will require the impossible. It will require someone that they had not acted in a way with respect to which they weren't able to form an actual intention. So there are other cases. What are some of the other cases that he talks about in under the rubric of laws requiring the impossible? I mean, remember when he says, at one point, when he talks about retroactivity, right? He talks about the fact that sometimes, for practical reasons, we'll have to make retroactive laws. More fundamentally, the very act of judging will justly be perceived by some people as retroactive laws. But actually, one of the problems with retroactivity is we don't necessarily even understand what it means. Same thing with impossibility, right? What is the line between impossibility and extreme difficulty? Right? He'll say at one point that we will sometimes say of something that would be extremely difficult for someone, right, that it was actually impossible. Right? Think about excuses in the criminal law. Right? Think about the famous case of the person who breaks into somebody's house in the middle of a storm in order to shelter themselves from the elements. Right? And in that sort of case, they can claim necessity, right? I didn't have a choice. It was impossible for me to act otherwise. Necessity. For those of you who have ever done any philosophy or logic, necessity is a pretty hardcore concept, right? It means I was driven by almost something like a physical impossibility of doing otherwise. How could you find me, guilty of having trespassed, right, when I needed to do this to save my life? Well, that's not an impossibility. Right? It just means that it's extremely difficult. Right? You risk your life if you don't break into the house. But it's still possible not to do it. So at what point do we draw the line between impossibility? A legal system that requires the impossible is not a system that is characterized by legality, and just extreme difficulty. Right? Is this a metaphysical or like an objective description, or is it a moral distinction? If it's a moral distinction, it means it's kind of up for grabs. Like different legal systems might draw the line in different places. So we don't have a hard and fast definition of what retroactivity is. We don't have a hard and fast definition of what impossibility is. And we could go through all of these 8 conditions where he tells us, it's terribly important. Clarity, right? Clarity, or publicity, right? This is a principle without which you don't really have a legal system. And then he says, oh yeah, but the degree to which you make a law public will always be function to marginal utility considerations, right? At a certain point, making it more clear or making it more available to the general population will incur costs relative to other values, either of internal or of external morality, that we may decide aren't worth incurring. Well, wait a minute, I thought that this was like an absolute value that the law had to aspire to. So, I guess the question that you look perplexed, or am I, no, not you, you're looking perplexed. It's not perplexity, that's fine, please do. So, generations of readers, or at least a couple of generations of readers, since this book was published, have been a little bit confused, right? There's a potted version, there's the sort of thing that you remember from law jurisprudence classes about Fuller, the internal morality of law. You try to remember at least 7 of the 8 principles so you don't fail the exam, and that's it. It's one of those things, it's so famous, the internal morality of the law, that in a way the book and the chapter are actually a victim of their own success. People think they know what's in it, so they don't bother reading it anymore. They get some kind of summary somewhere, the 8 principles, and then away we go. But yet, it's a much more complicated text than that, because he seems to be taking away with one hand what he's given with the other. He seems to be saying, no legality without these principles, but yet these principles have to be violated not only are they violated, but they must be violated in certain cases in order for the law to achieve its functions. So is it being contradictory? Is this an incoherent chapter? What is the status of these 8 principles if the simple interpretation, namely the legal system should try to maximally realize each one of them, if that interpretation is not correct, is not true? So that's the question that you're looking still a little bit, it's a hard question. I don't ask any easy questions. If you want to go to easy questions, go to another one.
就是说没有 如果没有 principle 就没有 legology， 但是 principle 一直会被违反，所以它难道就是说 legology 是没有办法实现的？其实本来就是这个问题。
Okay, so break up into groups. So yeah, it's a little bit too muggy to do outside. I think everybody would just melt into a pool of incoherent gibberish if we went outside. But if people wanted to go into another space on the floor, try to break up into different groups from the ones that you've had before. Try to make sure that you have different people that you're looking at relative to the people that you've had before, and try to appoint a different. You've already held a pen. One, don't hold it again yet. By the way, I'm gonna sort of mark the presentations, the little papers, when I have a batch of them. So when I get these back, I'll return them all the following week. So are you already sitting? The constellations that are already in place, people sitting. And I don't know, either you corner of the room or whatever.
That's a good idea.
Oh,
他不跟他们过去呢？我们不是不跟他们。
但是他们好像他们是要在一个地方。感觉这个马自己要跟那个。我们走了。OK。
Where are you guys going? I have to at least know where you are. Yeah. Okay. All right.
Okay.
You guys have to.
Wow. Great. Wow. Everybody comes up.
Do you have? Oh,
Yeah, we have a room.
cool. We have to find somebody who is doing. Yeah. I already did mine.
I'm gonna be.
I was hoping.
3, 6, 7. Okay, I'm gonna steal one of you. This is a group that's only 4.
Okay.
Yeah.
You gonna go?
Yeah.
Okay.
Okay, seven, sit on.
Yeah, there's only 4 on the left hand.
Okay.
I'm gonna start with you guys. Who's the pen holder?
We can.
trying to figure that out at the moment.
We two.
No,
together.
just one.
Okay.
Just one.
Me. This time me. Okay.
Okay.
I want this.
Okay. I can't remember people's names. I don't have my bat.
Sure. It's a Chinese name. Very hard.
Sure.
Yeah. SHUO. Sure. Yeah.
SHUO. Sure.
Yeah.
Yeah. Good.
Okay. So, who wants to be the first? And I record our discussion.
Is that okay?
Yeah, that's
Is
okay.
that okay? Thank you.
Okay, so the question is, Cora, if whether a flow takes a coherent position relative to the morality.
Yeah, so let me maybe sort of just to
Yeah.
prime ideas a little bit. So for example, when you look at, so sometimes it seems like there's just little technical obstacles to the satisfaction of the principles. So the case that he spends a lot of time talking about you pass a law saying on the 1st of May all marriage licenses have to have the stamp, but then the stamp machine breaks, it's only fixed on the 3rd, you have 200 marriages on the 1st and the 2nd, so you pass a retroactive law that validates the marriages that are passed before the machine gets repaired. That's like a little technical, it's like a technical fix, it's a patch that is, the reality sometimes just gets in the way of the perfect satisfaction of the principles, but there's no deep violation of the principle. But the thing about the interpretation of statutes in a conflict about in a legal conflict where a judge has to adjudicate in a conflict between two parties, either by saying you're right, you're wrong, or by saying neither one of you are actually right, this is the way I'm going to interpret the statute now. It's like somebody
we're boiling water.
rolling water. Okay, just wanted to make sure that it's not going to explode or something. It seems that there's something more fundamental. There's some kind of principle at work that he hasn't really made explicit in the body of the text that is justifying and making it necessary for the judge to do something that looks like it's violating retroactivity. So is it just that there's some principle that is implicit in the activity? Maybe I'm making things more confusing than is needed with this question.
Well,
Hannah.
the thing is, are we talking about retroactivity alone, or are we talking about the principles in general? Because I think what we have to give full credit for is he's not trying to single one principle out and focus on that one. For instance, saying this is the perfect version of cohesiveness of law. This is the perfect version of I don't know, publication of law, but he kind of identifies 8 principles and brings them in correlation. And I think that is actually the point where the contradiction comes in. When he starts making a concept out of several distinct principles and not focusing on one that is supreme.
I do feel that perhaps we answered the question a bit already in the end of the last session, because as I understood it, it's thinking of the marginal utility principle, that you can't realize all those 8 principles to 100%, and it's not necessary to realize them that much either. You just have to realize them to a certain extent, that the internal morality of law is satisfied, and the rest is external, so it can be higher or lower. But the higher you increase one principle, the more you have to make concessions with the other principles. It can't be realized all to a full degree. So I don't think it's incoherent.
I also think it's incoherent.
You think it's incoherent?
No. I think it's not coherent.
It's not wait, I want to make sure I understand. Not coherent or not incoherent?
It's not coherent.
Okay.
Yes. It just gave one important step in this discussions. He don't tell us how he concludes this 8 internal moralities.
Right.
It just formulate stories and just list 8 principles. It don't tell us where is the internal moral come from.
Okay.
And
so that's a good point. Where does he draw the 8 principles from?
Yes, it is. Yes. And I think, this is the first question. And then the second question, the second problem is, if further in his chapter 2, he says the principle of the principle of marginal utilities will play an increasing role in the moral decisions. It means he wants to use the economic economic calculations in the moral decisions. But I think the economy and the morality, they are 2 different things. The economy is about the utility side, or I can say the value side. It's about the value is more or less, and the morality is about the judgment, wrong or right or good or bad. They are two different things. Even I admit, okay, you can use the economic conclusions in your moral decision to deal with the complex between the external morality or internal morality complex. But Fuller didn't give us the utility functions. So
okay.
I do think I disagree because what he actually did with the distinction between internal and external morality, he did quantify the degree to which morality is realized. So by quantifying this, you can actually apply economic principles like the marginal utility. It's not about whether it's wrong or right to have certain of those principles realized. It's just the degree to which it is. Mm-hmm. So that's why I think you can actually use the marginal utility.
What does he say about the principle of utility? Does he believe that it actually, what does he say about the actual idea of utility as it's been used by, not in this chapter, in the chapter before? He talks about marginal utility reasoning, which is, the structure of marginal utility reasoning is something that is familiar to us from economics, from economic reasoning. But the actual idea of utility, what does he say about it?
It's ubiquitous. It's used in many.
I think the best benefits. He wants to achieve the best benefits of the.
I mean, he's pretty skeptical about the idea of utility, isn't he? He says, we bandy it around as the meta principle that is going to allow us to adjudicate between, when it is that we should stop pursuing one value and maybe start pursuing another value. Well, we decide this on the basis of a meta principle of utility, but, that's just a kind of a hand waving, right? We don't really have a good conception of utility. We know that we do marginal utility thinking outside of economic, even outside of purely economic spheres. I was using sort of everyday examples to show how, even without realizing that we're doing it, we often, how much time should I spend cooking tonight? Mm-hmm. I know that if I spend half an hour extra relative, I can get this much more sort of taste value, but maybe I'll spend half an hour less time with my kid talking about her day or something, and I'll get less parenting value. Is there some kind of meta value that we can use to balance these out? He says, no, probably not. Utilitarians are wrong in that. But do we still think in this way? Yes, we do. But we just do it without this safety net of the utility function of the principle of utility. I was going to say something else though, just to try to prime us. So there's what I tried to show, and when we talk about whether or not there's something incoherent going on, there's kind of three levels there's three different kinds of reasons that Fuller gives to say that we can't fully realize these values, and they can be seen as being an increasing degree of worryingness. One is the easy case. Sometimes facts, get in the way, and we just have to make a quick fix to something where facts have prevented us from applying a principle. Then there's the inevitability problem, right? It's inevitable that we're going to use retroactive legislation sometimes because adjudication is just saying of a rule that we thought of one way yesterday, that this is the way that we're going to think about it today. So there's a form of retroactivity there. But then there's a third level of worryingness, which he makes explicit in the two principles that I spent the most time talking about, retroactivity and impossibility, where he says, you know what? We don't really know what these criteria mean, right? We think that they're hard and fast and objective, but in fact, when you think about it, on the one hand, I'm telling you they're very important and no legal system can operate without them. But on the other hand, I'm telling you that they're pretty complicated to actually figure out what they mean. Is a change in the tax law, to some degree, any change in the law which changes the situation of a person relative to what she thought would be the case legally before is, in a sense, a violation of retroactivity. So how come we don't worry about all of these things? We can't, because if we did, we'd never change the laws. So it's that impossibility. It's, on the one hand, we're saying that some principles are necessary, and on the other hand, we're saying that we don't really understand what they what they mean. When we try to apply them in an absolute way, they sort of crumble before our eyes. Impossibility? Well, telling you to jump 20 feet in the sky, that's impossible. But telling you that you're not allowed to break into somebody's house, even if that's needed to save your life, we're going to do away with the doctrine of necessity. Well, that's not impossible. It's just very, very difficult. There's no physical impossibility there. So that's where, maybe one of the things that you focus on is where he's telling us that on the one hand, these are terribly important principles, but on the other hand, we have no idea what they mean. Okay, I've just killed the discussion. You can take it in another direction.
But I do feel that the law usually gives us answers to these questions. I mean, obviously not everything can be written ahead in words, but by leaving a room of appreciation by the judge, it gives us answers to those questions. And the legal system provides us with certain authorities who would decide to what extent something is impossible or not. I mean, it is pretty clear when necessity begins in criminal law, right? It's not and we not everybody has to decide it for his own, but we do have a certain court as authority who would tell us.
Okay.
Right.
But I'm participating in the discussion too much. I'll just say one more thing, and then I'm going to go away and let you guys discuss. But all of a sudden, you're right, by the way. You're kind of right about the functioning of the legal system. But all of a sudden, it starts seeming as if the way you described it, which is correct as a description of the facts, these principles stop operating like external constraints on the law and start functioning like, so is that a problem? Do you see what I mean? You're Ingo, right? Mm-hmm. You're absolutely right that this is part of the vocabulary and the conceptual repertoire of judges. But if they get to determine, okay, for our jurisdiction, this is going to be the point at which the doctrine of necessity starts. And by the way, the doctrine of necessity is understood very differently in different jurisdictions. It seems like it's no longer functioning like an external constraint. I'm going to let you guys talk amongst yourselves, and then we're going to go to another group.
I think that, by leaving that room for appreciation, at least it gives an enough amount of an enough degree of certainty. It gives an enough degree of certainty so the internal morality law is satisfied, and everything above what I said is up to the legislator to decide. You can't fulfill all, so you can leave this room of appreciation, and it's only a question of prioritization between the principles, perhaps.
In international, there are two big approaches: predictability, flexibility. You find a balance in between. So laws tells you what you should predict as a person, but you cannot always regulate everything. Otherwise, it won't reach the purpose of justice, ultimate justice, because there will be some gaps. In certain situations, in sui generis situations, when you consider case by case, there has to be someone consider. At that moment, there should be flexibility as well. I think this is what you're talking about. But is it directly related to
what he
question?
said is whether it stops being an external constraint or a factor to assess whether legality is fulfilled or not, right? That's what he said. And from this external factor, it becomes a rather internal thing, right? That's what he said.
But, do we have to, make a principle one thing or the other, or can't it be both?
Yes.
Can we not just say, as an external measure, we want consistency, we want non-retroactivity, we want publicity, we want all of that as an external measure of the law. But internally, we must realize them, and as soon as we start realizing them internally, they become internal. It's why can't it be both?
But I think in the chapter 2, the Foulardon discussed this internal morality in an effective philosophy background. And he just positivism to summarize this internal morality from the common law. You don't discuss this in a philosophy. So I think it's difficult for us to realize this internal morality.
Well, actually, that's the thing. I don't think that the 8 principles so much are distinct from what the positivists say about the law. I think that's very much, what Hart already conceded must be in a law. with exceptions, and you can argue about little things. But I think Hart already conceded that there are some things that are must fulfilled to be law. I think, in that part, he doesn't that much differ from the positivists.
That's how he come up with this 8 morality of laws. Is he just give this 8 morality? He summarized it from the practice of law, the procedural practice.
Yeah, he used this example of the King Rex to start extracting from that example how would be a legal system if you don't use those 8 principles. Like this King Rex was like practicing and having mistakes, and of those mistakes he was understanding that, I can't, for example, I can't prescribe a law, a specific law, if I don't make it public for my subjects, for example. And that there you have this principle of publicity, for example. So I guess that he's trying to say that if you in the daily basis you try to regulate some things like without having any kind of principles, you're going to have some mistakes, or you're going to realize that you need some essential things that at the end are these 8 principles. But yeah, I agree with you that we don't know if maybe there are 9 principles and he just
missed one.
Yeah, it's like,
Which is the 9th?
Yeah, I don't know. I mean,
maybe 9, maybe
10.
Maybe 10. Maybe.
Equality.
And I think more can be aspired.
What?
Predictability, let's say.
Yeah.
Didn't he? I think
I don't know. Equality, predictability.
Equality wasn't in there. That's true, but predictability was in there.
There is consistency.
It's
or
consistency over time. Yeah.
And flexibility wasn't in there either.
No, I'm just making up. Like you can make a list of 50. I'm just making up right now. I'm not saying this.
So it is a very subjective standard. So how he concludes that.
Yeah.
You know what? This is a good point. I think we can say that there are 5, 6, 8 elements, but this 8 elements itself is not like there are more elements. He made 8 categories, but we believe there are more. Like he's not very close because he cannot say only these 8. Like I mean,
At least
maybe there are more.
Why just those 8 principles and why not one more, for example? I in this point I think that maybe Fuller is like acting the same way as Hart. That I felt like Hart was like imposing a concept of morality and law, and he didn't even explain what was the concept. He was just comparing those 2 concepts without defining them. So this is morality for me, and this is morality for all of us that we are discussing. And now Fuller is trying to reply to that, but also he's saying, well, these are the 8 principles we need. And of course, in our legal systems, of course, we know that we need those principles because it's what we have learned in law school. But yeah, maybe there is another legal system that.
For example, I'm checking online. I just wrote like pillars of rule of law. For example, law applies to everyone. Equality. It's not there. Okay, and law shouldn't be secret or arbitrary. That's good. Like
secret.
Yeah, it's there. It's there. But arbitrary, like what's the opposite of arbitrary?
Well, we have contradictory and we have impossible.
Let's say fairness. It says law has to be fair.
Fair. Okay.
Fair.
Well, that's not
in a way
what
to enact and also to enforce. And equality, flexibility, like this kind of. I'm just one website, but we can make a point. Okay, he limits the internal morality to 8 elements, but these elements are, how do you say in English? Cannot be numbered, cannot be limited to a number.
Okay.
So it's just, you know, an open list.
Yeah, open list. Yeah, exactly. We can make this point just to, it sounds interesting.
So,
If we agree.
so but that would even add to the contradiction, because if we throw more principles in the mix, we get even more contradiction in a concept, you know.
But
Just he don't tell us how he get this principle from the morality of exploration.
exactly.
Where I can realize the morality of exploration.
If it's
Everyone has
yeah.
his exploration. This is full of internal morality. I can have internal morality.
Exactly. He said that law is aspiration, and these 8 principles is what we aspire to in a legal system. But as our personal lives, and as he was explaining with these economic examples, aspiration for you can be one thing, and aspiration for me, like having a really good life, can be another thing. So why is these 8 principles what every legal system aspire to? Just these 8 principles. If it's aspiration, it can change between different legal systems.
Yeah.
So can we say that if the law goes in one direction, the direction is in the upside the aspiration. So we can say
Maybe in one point in history we can realize that we needed another principle, an extra principle. I don't know, what do you think?
I think it's rather on a, like, I couldn't think of another principle. I think these are like the basic principles to make a legal system
Well, we had
work
3 right there.
Yeah.
So we already.
No discrimination or equality or
Yeah, equality, non-discrimination, fairness, flexibility, predictability.
Predictability is
I
important.
think
And I was thinking, for example, now
this is I think the difference is these are rather substantive requirements for a system
But
of
no,
law.
he's
not-
talking about how laws can be moral or legal, which elements you have to.
Yeah, but I think he has a different.
Because rule of law is kind of this side of the inner morality, The elements of rule of law is exactly what's the legality.
But don't you think there could be like a totally cruel and arbitrary system in substantive terms, like which has death penalty for a lot of things, and then at
Death
the same
penalty
time
is
fulfill
substantive?
all these 8 requirements and be
But
like
then
a legal system which
then
can
we're-
be, which the people can submit to and they can predict, so they can.
Yeah.
So it is a legal system that would work,
But then
even
we're
if it's
all,
arbitrary.
And in
But
that
same
sense,
for
he's
retroactive.
acting,
So I
he's
think it's
saying
rather
the
the-
same thing that Hart.
So I
Right.
think
Yeah,
it's rather
but-
objective requirements for a legal system to work,
but then we're back to the positivist idea of law. You
Yeah.
know, that is actually, that then it's actually not that different from what Hart is saying.
Exactly.
So,
Yeah, he's not being very coherent. That's the conclusion. And well, yeah,
He's
I'm getting confused, but Fuller is
Fuller is supposed
no,
to-
Fuller is
yeah.
supposed to be not the positivist.
Exactly.
He-
I understood last class that he believes in that there is moral comes from God, or what you understand with God, and if he is coherent with that idea, so these 8 principles, if you, as you said, Nazi legal system can
fulfill
comply
those,
with
yeah.
these 8 principles and still be evil.
Yes.
So what does Fuller say in this situation?
He says, pardon, sorry.
No, yeah, I'm asking.
This is inner morality. It's not substantive law. So his point is to make a law can be efficiently executed. You have to balance them: inner morality, external morality. Inner morality, the kind of the way how you enact laws. Okay, it has to be consistent, not contradictory, non-retroactive, etc. Substantive law is external morality. Don't kill, don't do, don't help each
They
other.
have to be always.
Yeah, exactly. Like, if it is only like on substantive law, if you have Nazi law, but in the morality, you still use this principle, it still doesn't legal, you know. So it has to be combined both, I think.
Yeah.
His point is to me like he's just trying to make this connection. How to efficiently execute a law. You have to have legality. How to have legality? These 8 principles. Okay. So how legality comes through morality. Like morality, legality, marginal utilization, and full execution. The ideal law system. I think he's trying to make this connection.
And in this connection, we, he and we can conclude that law can't be able to be law, or it's just law as Hart said.
Yeah, I do have the impression that he has a different understanding of morality. It's not the question of anything being good or wrong, right? He just has these objective requirements, more of a procedural
It's
thing,
very
you
similar
know?
to Hart.
Yeah, it's similar.
Yeah.
Like the positivists, they would say, well, it depends on the process, how the law was created, and he says, not the process itself, but the law has to fulfill certain objective criteria to be considered legal as a legal system, like to fulfill this legality criterion, but there is no substantive requirement whatsoever if it should be good or wrong.
He's missing that point, right?
Yeah. So
Okay,
he's
we can make
actually
a conclusion, yeah.
And it's an important point if we understand that he starts from the point that there are basic moral rules that comes from God, and that we need to live in an organized society.
no what?
In an organized
Oh,
society.
yeah, yeah.
Can we make bad laws obeying these 8 criteria?
Yeah, we can.
Yeah.
Nazi
This
law.
is some point that he's missing, right?
Nazi law. Let's
Let's
check the
yeah.
criteria if Nazi law was
It was general,
fulfilled.
Yeah, it was
Who is the?
consistent,
Consistent?
non-retroactive,
Well, sometimes it was retroactive.
but the laws
Yeah.
after Nazi was retroactive. Nazis were just saying, you know, if someone
Well, some of it was retroactive.
Yeah, some
right?
of it was like
Killings that he got
retroactively-
justified afterwards.
Yeah,
but
yeah,
in
they
total,
did-
like that's not what made the system evil. Like
yeah,
you could
that's
imagine that
that's
the
the
system
point.
is.
They just went beyond and even disregarded
Yeah.
these eight.
But you could think of an
these
evil
were
system.
retroactive laws that they did.
Yeah, they just made retroactive law if they wanted to punish somebody for something he had done that was.
I see.
Yes, they
So
just did
Hitler
that.
had like went to the. Was it an example in the book when he went to the south killing people and then he went back to
No, that was
make a
an
law?
example.
No, you can pardon. It's not retroactivity. I mean, retroactive fully doesn't expand, but my understanding, you cannot hold someone responsible for something that he did in the past, which was not a
Yeah. That was what the.
crime, but you can be retroactive to pardon people. It's not a
So
problem.
it's-
No, it
that
wasn't
was
about
a-
pardoning.
that
It was
was
about
a-
killing people and retroactively justifying the killings.
You can justify, no problem. But you cannot.
No, I mean, no. You misunderstand.
Hi guys.
No,
Hi
the
guys.
killings were not on a private, like a private individual killing people and being
I don't
justified.
think
But
that he's
it was
justifying the
like it was legitimized as an act of a court ruling with immediate punishment.
No, that's
So-
terrible. But the prohibition of retroactivity means that this is a criminal law principle. You cannot use this principle
But,
against
but
state
it's
law.
not the same principle Fuller employs. It's not the same. Fuller
Okay.
has a more general idea of
Okay.
retroactivity.
But
I
we
think.
have retroactive laws everywhere.
Yes.
When
But
you
that's the
pardon
point.
criminals, it's retroactive. I think he means
No,
that.
not really.
No, I think.
But I'm also speaking of a different thing. Like he sold his killings as being a court judgment and punishment for a criminal behavior which was not criminal before. So they made a criminal
Yeah, that's
retroactively,
retroactive for sure.
and then
All of them retroactive.
Yeah.
That's real the
Yeah.
principle that we are talking about.
let's advance with the other principles. What else do we have?
Promulgation, applications,
Yeah, publications.
That was pretty public, I guess.
Yeah.
what they did.
They, well,
generality.
Yeah.
yeah, sort of. Or is it so general if it applies only to a certain ethnicity?
Can I have a question?
Yeah, sure.
Yeah.
Is Fuller says that the publicity, the publication is the moral of duty, and the other.
He said in the constitutions we can list morality in the constitution law, so the constitution law can protect the publications of the laws. And he said that he thinks that all these principles, they are all the morality of aspiration.
I think Fuller says that the publicity is necessary. It's one of the elements that can not be delayed or cannot be removed from the removed from the 8 of these moralities.
Elements,
Yeah.
He mentioned that. So publicity is different from other 7 moralities.
Okay.
That's why.
Why is it different?
Yeah.
It's one of the most basic elements and the basic important element.
Which has to be fulfilled.
Yeah.
Why? Yeah.
He also said we can sacrifice other principle and to make other principle more expressive.
If the purpose of legal system is that people can organize their lives, they have to know what they can do and what they can't do.
Yeah.
So they need to have public laws, public rules, and a place where you can go and see what can you do and what is prohibited.
So when we violate publicity, at this time, the legality is not exist. But when other 7 moralities are violated, is that any? I mean,
it's not so bad if you mean that if it's not so bad if you violate one of the other 7 principles.
Yeah. Is the law still valid or the legality still exists?
Again, yeah, you can violate it to a certain degree, right? To a certain extent.
I mean, it cannot be like 100%, yeah.
Huh?
So you have to, I mean, not all the laws are 100%, you know.
But I think even promulgation can't be reached to 100%. I mean, there's so many internal administration procedures which you're not aware of as a citizen. So
for sure.
it's the same for that.
But we know 1 out of 100 laws, you know.
Yeah. I mean, no, I think the possibility to know it is enough. Like, you don't have to know every single law, but like you must be able to read reach it. But there's so many also like internal procedures which have direct impact perhaps on your case, how it is treated, but you wouldn't be able to access it, right?
Yeah. And this, yeah, I think it's more about like, you know, there are laws that people don't know and they cannot read, you know, only some certain groups know it, so that's a problematic thing. Secret laws, you know, secret books behind the doors.
But Fuller talks about it, and he just says it is important that, he just says that it's absolutely impossible to educate everybody on every law in the system. Even we're law students, but I don't know about German tax law, and I don't want to find out. Not really, So, and he says the important thing is that those people who want to be informed or who need to be informed can take certain steps to get there. So, if I wanted to learn tax law, I could, try to learn it or hire an accountant to do that for me.
Oh, yeah.
And there are finish, please. Sorry.
No.
there are legal systems, as mine, for example, and one of the principles there is that the state assume that the citizens already know the law.
That's, I think, in every legal system.
Yeah, and if your country is very poor, you don't have people with internet, for example. So, and of course, you don't have people with enough money to buy a criminal code, for example. And if you have to choose between eating and buy a criminal code, you're going to eat. So, people don't know the law.
Yeah, it's an illusion that people. I mean, I think the state needs to this presumption that everybody is aware of what is like the governing law, but it's an illusion. I mean, even by looking into a statute, how would you possibly identify what behavior is illegal and what is not? Like even for lawyers, that's difficult, and it's up to discussion and statutory interpretation. So a normal, like a lay person, how would he ever be able to define that?
You
it's
can
just an
have a very bad idea of what you can or what you can't do. Like, I think it's prohibited for me to kill someone.
Yeah.
But
and then it's very rare that something is prohibited and you would say, "Wow, I would have never thought that was illegal."
Yeah.
Like usually it resembles your moral.
Yeah, but I think he writes about this as well when he says, you know, the more a system actually replicates the values of the people in a society, the less necessary it's to publish the law. We all know that stealing is, you know, a bad thing, so we're not surprised to find out that there actually is a punishment for doing so.
But that's what he said. Like for the for the worst criminal activities, it's not even necessary to publish the laws because people are aware anyways.
Maybe he can say that, well, okay, poor people is not going to buy a criminal code, for example, but if one of those people do something and they need or they are going to be in a legal process, at least they have the possibility to have a lawyer that is going to know the law.
So we're talking about legal aid.
So maybe Fuller is going to say, well, that's your publicity. Someone in your country knows the law, so go to him.
Yeah,
or her.
but probably. Yeah, that is. I think that is at least part of publicity.
So if we want to make a conclusion, because we're running out of time, so I will just say 1 minute, some points that we collected here, so and then we will discuss. So I'll just speak 1 minute. So some criticism against Fuller in this inner morality is one, he doesn't clarify where these elements emanate from, where they come from. Second, these elements are not exhaustive or open list. So how he can limit to 8? This is your point, and the first point was yours. And third point, as Ingo said, you can make bad laws abiding by these 8 elements. Maybe we can make a Nazi comparison. Ingo, can you make that?
Yeah.
Just basic, you know. This is the third point. And fourth, it's my argument. There is a lack. The inner morality is not connected with the substantive law. There should be a connection. Some bad substantive law can be covered by these 8 elements and look like a moral, but bad laws, relates to what you said. So 4 points. That's what I understood from this discussion. You want to add something?
Okay, fine then, madam.
So anybody has some contribution or opinion to?
So how are you gonna make it? So are you gonna write these for you?
Yeah.
Have you used Google Docs before? Google Docs.
No.
Did you use it before?
What in China we can use Google?
Google Docs. So we did before Google Doc. It's super easy. Okay, so I can create the document actually right now, and then everyone can write their email address. I'm gonna work on it.
Okay.
And then everyone can, for example, I can write my part, you can write your part, and you can write your part. You can make like basic Nazi comparison maybe. Can you do that?
You wanna do her work, or why does it?
No, she's gonna draft.
Yeah. Oh, you want to help?
Yeah, I'm just gonna create the documents. So and then afterwards, after she drafts.
So we just can fill in if some gaps appear or something.
I don't know.
I don't know if she wants that. I mean,
no, she's gonna write.
She's gonna be great for it.
I'm just trying to.
Yeah, just take our email addresses so we can.
Exactly.
It's a good idea, but it sounds like work.
Just hush.
Assignment 3.
So.
Wait, assignment? Is it an assignment?
So how to use the Google Doc?
What are you talking about? Is it an assignment everybody has to do?
Yes, you will have to do that
What?
too.
What do I have to do?
Leading a discussion, writing a report.
Yes, I know. Yeah, sure, but it's not an assignment.
Or discussion.
No, you're just helping out.
You don't want the
fellow
pressure
classmate.
of an assignment.
So you're trying to be a nice
Well,
guy.
did you ask her if she wants that?
Do you have Gmail?
Because she's gonna be great for the shit I produce.
Gmail.
We just
You have
right
Gmail?
now we're just collecting
No.
our email addresses.
Okay.
She's not obliged to use them.
Have you heard of data protection?
Okay. Up to
And
you.
give
If you
her
have other
your
methods
Gmail-
you can write,
your
then
McGill
you can
email.
send through email to us, or
Don't.
how do you
Just kidding.
Don't use data
about this?
protection.
Everyone can type at the same time. Everyone can reach.
Don't
I'm
use
just kidding, Hannah.
I know.
Everyone can reach the same document.
Nobody has
Is
chocolate.
the Google Doc,
It's
I want
something like
chocolate.
that.
There's one chocolate cookie left up
So
there.
everyone
you
can.
mean everyone
No, you can
writes
have.
No, you
I
can
want.
do that.
No, you will write,
I will.
and
Yeah.
afterwards
So-
you will show people,
Sure.
right?
Oh yeah.
And then
Pika
everyone
chocolate.
can see and leave comments. Hey, this part.
Maybe I can send email
To you.
That's perfect. Okay. Yeah, it's easier. Yes.
Just write down
So
your email.
yeah.
Yeah.
Just
So I
write
was-
down your name. So
The
course.
McGill
Send your
email.
emails.
Yes.
Here.
After we finish the report, we will send to you.
China Life. What's that?
It's an insurance company.
Oh,
I
okay.
got this book from.
But you don't work for them.
No, my mom worked there.
Oh, okay. Where are you from in China?
Beijing.
You too?
No.
Where are you from?
Fuzhou.
Fuzhou?
Yes.
Have you ever been in China?
I would like to go. Should I go to Beijing or somewhere else? Or to Fuzhou?
Beijing.
Fuzhou.
It's a boring city.
Because China is so big.
Yeah, it's
So
Did you
massive.
send?
I don't know what you like. You like culture or you like the national seas?
But I.
But
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 you
you
must
said
go to
that-
Beijing.
you said that, for example.
It is
Yes.
very.
Yeah.
It has a very
Yeah.
unique tradition
Oh my
in
God.
China. You can
That's great.
have a
Yeah, it's
very different perspective of China if you go to Beijing.
Also, Nanjing is a very amazing city.
oh yeah?
Nanjing, yes. Also, let me think if you want a picture.
Because very historical sites are in Beijing, like the Great Wall and the Summer Palace, and the Forbidden City.
Oh yeah.
Yeah.
Do you have theoretical approaches to law also in your university back home? In Chinese university?
No, we seldom started this
Do you
before.
want me to?
Hmm? Oh, what do you mean you started?
In our university, this kind of class is very,
Sensitive.
yeah.
Oh, because it's like philosophic.
Because every our WeChat, our emails, we check every day, and everything you said in the for example, you say something about advisor, say she has a bad temper tomorrow.
You'll be expelled. Oh yeah?
Thank you.
Yeah, I heard about that. I heard about like some stuff that at Australian universities they fear that freedom of speech is impeached because when Chinese students go there, they sometimes don't dare to express their opinions because some people would report them back to the party.
Yeah.
And so
Yeah,
people
so-
don't really dare to speak in classes.
So far,
Yeah.
we don't want to say too much because I'm
I
very
can understand.
common.
Yeah.
So if I have any questions, I may email to you
Sure,
guys.
sure.
I'm very glad if you can help me.
Oh, sure.
Of course, yeah.
Thank you
We'll be
so
happy
much.
to do that.
So
Yeah, thank you so much.
thank you for initiating that.